The morning began like any other at the downtown federal courthouse, the kind of morning when routine made everyone careless. Lawyers moved through the revolving doors with leather briefcases in hand. Clerks balanced thick stacks of files against their hips, and reporters lingered near the security checkpoint, hoping something unusual might finally justify their presence. Word had spread that a new judge would be taking the bench to help manage an overcrowded docket, though almost no one seemed to know her name. Rumors traveled through the hallways faster than facts. Some claimed the appointment had come directly from Washington. Others insisted it was nothing more than a temporary reassignment from another district. Before long, the whispers had become gossip, stripped of accuracy but swollen with certainty. No one stopped to ask why the appointment mattered so much. They simply sensed that the building felt different, as if the day had arrived carrying a significance no one could yet explain. Through the heavy glass doors walked a woman most people barely noticed. She wore a navy suit softened by years of use, the fabric slightly worn at the cuffs, and flat shoes chosen for walking rather than display. She wore no jewelry and carried no visible symbol of status. The only thing in her hand was an old leather satchel that looked as though it had traveled through more courthouses than many of the young interns standing nearby. Her expression was calm. So calm that it unsettled people who expected uncertainty from strangers entering an unfamiliar building. A few clerks assumed she worked in custodial services. Others guessed that she had come to file documents for a relative. They were the kinds of conclusions people reached when someone did not resemble their private image of importance. She offered no explanation. She simply continued forward with the quiet determination of someone who had made this same walk in many buildings, under many circumstances, and had long ago stopped needing permission to trust her own place in the world. That composure caught the attention of a young court security officer stationed near the entrance to the attorney's lounge. His name was Officer Wade Mercer, and although he was still relatively new to the job, he carried the rigid certainty of someone convinced he already understood exactly who belonged inside a courthouse and who did not. He watched her approach the restricted corridor leading toward judicial chambers, an area reserved for judges, senior clerks, and properly credentialed attorneys. In his mind, the situation required no investigation. A woman dressed so plainly, walking with that much confidence, had to be lost, or deliberately entering a place where she had no right to be. He stepped directly into her path and raised one hand. His voice carried the polished authority of a man accustomed to compliance before explanation. The woman stopped, met his eyes without flinching, and waited until he had finished speaking before offering a single word. People nearby began slowing their steps. Several lawyers standing near the elevators turned toward the exchange, more curious than concerned. The atmosphere shifted almost imperceptibly, the way it does when an ordinary interaction begins leaning toward something no one has yet decided to name. No one intervened. At that point, no one believed intervention was necessary. Mercer remained planted in front of her, his posture firm and his tone sharpened by the impatience he reserved for people he assumed would not challenge him. The woman reached toward the leather satchel at her side with unhurried precision, as though she had expected this interruption long before she entered the building. What followed would remain in the memories of everyone who witnessed it, though in that moment, almost none of them understood how much it would reveal. Mercer told her flatly that the corridor was restricted to attorneys and court personnel and ordered her back toward the public waiting area. She replied in an even voice that she had every right to stand exactly where she was. He laughed, a short dismissive sound intended as much for the surrounding audience as for her, and repeated the instruction as though she had failed to understand simple language. A few passing attorneys slowed, drawn less by the words than by the friction beneath them, one person refusing to be dismissed, the other refusing to listen. Among them was Preston Hale, a defense attorney known throughout the courthouse for his expensive suits, theatrical arguments, and appetite for an audience. As he passed, he smirked and remarked loudly that everyone seemed to believe they were a lawyer these days. A ripple of laughter followed him down the hall. It was the kind of laughter that cost nothing to those giving it and everything to the person expected to absorb it. The woman did not react. She opened her satchel and removed a folded document, a temporary judicial appointment letter bearing an official federal seal and the signature of the circuit's chief judge. She offered it without ceremony, the way someone presents credentials she has been required to produce too many times before. Mercer barely looked at it. He waved the document away and declared that he had seen forged papers before. He said he would not be fooled by something anyone could print from a computer. He did not care what the letter claimed. She was to leave the corridor immediately, and any further argument would only make the situation worse. She held his gaze for a moment, then took a single measured step forward, intending only to continue toward the chambers she had every legal right to enter. That one step was more than he was willing to tolerate. His hand moved before most people fully understood what was happening. His open palm struck her across the face with enough force for the sound to crack through the marble hallway like a gunshot. Every nearby conversation died at once. For a suspended instant, no one moved. It was the terrible stillness that follows an act too shocking for the mind to accept immediately. The woman's head turned slightly with the blow. Her hand rose instinctively to her cheek, but she did not stumble, cry out, or step backward. Near the elevators, a young court clerk gasped. Somewhere behind the gathering crowd, someone released a brief, nervous laugh, the sound of a person unable to process horror and choosing the weakest possible response. No one stepped forward. No one asked whether she was hurt. The hallway was filled with lawyers, clerks, officers, and other professionals whose work revolved around justice, yet they stood watching in silence. She did not scream. She did not lunge toward him. She remained completely still, one hand pressed against her reddening cheek, her eyes fixed on the officer who had struck her in front of a crowd. The silence stretched until it became almost unbearable, broken only by the faint shuffle of someone shifting uneasily, unable to decide whether looking away would make the scene less shameful. Mercer straightened, apparently satisfied that he had reestablished control. He reached for the radio clipped to his shoulder, preparing to report a disturbance rather than confront the violence he had just committed. The woman slowly lowered her hand and looked at him with the quiet, unwavering focus of someone who had already decided she would remember every detail of him. Then she did something that confused the witnesses even more than the strike itself. She smoothed the lapel of her jacket with deliberate care, as though preparing to enter a meeting rather than recovering from an assault. She retrieved the satchel that had slipped from her shoulder and touched 2 fingers to the corner of her mouth, checking for blood. There was none. Every movement carried the same unsettling composure she had displayed from the moment she entered the courthouse. It was not the calm of someone who had failed to feel the blow. It was the calm of someone who had already chosen how she would respond if cruelty ever arrived wearing authority. When she spoke, her voice was so quiet that those nearby leaned closer to hear her, yet her words carried farther than any shout could have. "You have just made the greatest mistake of your career." The statement settled strangely over the hallway, too controlled to sound like a threat, too certain to be dismissed as wounded pride. A few onlookers laughed again, assuming she was trying to reclaim dignity after being publicly humiliated. Hale, still lingering with several colleagues, called out that threatening a court officer was itself a crime, clearly enjoying the spectacle far more than decency allowed. Mercer's expression hardened. His hand drifted toward the handcuffs on his belt as he announced that she was under arrest for threatening a law enforcement officer inside a federal building. He reached toward her wrist. Before his hand closed around it, a frantic voice rang out from the direction of the chambers. A senior court clerk in a cardigan hurried down the corridor, calling, "Your Honor!" with such urgency that several attorneys instinctively turned toward the courtroom doors, assuming she was addressing one of the judges already inside. Mercer paused, confused, his hand hovering near the woman's wrist. The clerk was Marjorie Bell, a woman who had served in that courthouse for many years. She did not slow until she reached the gathering and stopped directly in front of the woman who had just been struck. The silence that followed was different from the silence after the slap. This one was heavier, filled with the dread of people beginning to understand that they had judged the situation catastrophically wrong. Marjorie apologized repeatedly, her voice trembling as she explained that she had been searching throughout the building, unaware that the new judge had already arrived, and even more horrified that this was what had greeted her. Then she turned toward Mercer. "Do you understand who you just struck?" she asked. His mouth opened, but no coherent answer emerged. The confidence drained from his face so quickly that even those standing farthest away could see it. Hale's smile disappeared. His eyes moved between the clerk and the woman in the worn navy suit as the truth assembled itself in his mind. The attorneys who had laughed now stood rigid, suddenly aware that the joke had never belonged to them and the woman had never been its proper target. Marjorie carried a black judicial robe folded carefully over one arm. She held it out with the solemn respect usually reserved for ceremony. The woman accepted it without triumph. She slipped her arms into the sleeves and adjusted the collar with the same steady precision she had shown while straightening her jacket after the blow. No one spoke as the dark fabric settled over her shoulders, revealing what their assumptions had hidden from them all along. She thanked Marjorie quietly. There was no satisfaction in her voice, no vindication, no need to humiliate anyone in return, only the measured composure that had never left her. Then she turned and walked toward the courtroom doors, leaving behind a corridor full of people who finally understood, far too late, who had been standing before them. Officer Mercer remained rooted to the marble floor. His authority had collapsed into panic, and as he watched the robe move away from him, he found himself unable to say anything at all. Inside the courtroom, the gallery filled rapidly as the story traveled through whispered conversations outside. Attorneys took their seats with unusual stiffness, repeatedly glancing toward the bench where the newly appointed judge would soon appear. Reporters who had come for an unrelated case hurried to secure better seats, recognizing that something far more consequential than the scheduled docket had unfolded. The bailiff called the room to order, his voice slightly unsteady. When the door behind the bench opened, everyone rose in the practiced gesture of respect demanded by courtroom tradition. This time, however, the silence beneath that gesture carried shame, anxiety, and expectation. The woman entered with the same composed posture she had carried through the hallway. She took her place in the high-backed chair as though she had occupied it for years, arranged the files before her, adjusted the microphone, and looked across the room without revealing anything of what had happened moments earlier. The gavel came down once, sharp, controlled, final. The sound seemed to close the door on every lingering doubt about her authority. Officer Mercer had been escorted into the courtroom to await instructions. He stood near the side wall with his hands clasped tightly, his face emptied of the certainty he had displayed in the corridor. Preston Hale sat at the defense table for an unrelated matter on the docket, visibly uncomfortable now that the woman he had mocked held complete authority over every argument he intended to make. Before beginning the scheduled proceedings, the judge looked directly at Mercer. "We will speak after this session," she said. There was no anger in her tone and no threat, only a plain statement of fact. He nodded once, unable to form a reply. Then she turned to the docket and began the day's work as though nothing unusual had happened. The first case involved a complex contractual dispute between two corporations, the kind of dense, technical matter that often drained energy from a courtroom almost immediately. Hale represented one of the parties and approached the lectern with the polished confidence that had carried him through countless appearances. He began presenting his argument with familiar theatrical charm, relying on tone and presence to give his reasoning greater weight than the substance deserved. The judge interrupted him with a precise question that exposed a flaw in his argument almost at once. Hale stumbled, recovered, and attempted to continue. Another question followed, sharper than the first, cutting through the foundation of his position with exacting clarity. The courtroom began to recognize that something remarkable was happening. This was not merely a competent judge managing a routine dispute. This was a legal mind operating at a level many of the attorneys present had rarely encountered. Hale's confidence fractured with every ruling. His objections were overruled with citations he had not considered, and the strategy he had expected to control the room unraveled beneath questions that revealed knowledge bordering on encyclopedic. As the session continued, the laughter from the hallway seemed to belong to another lifetime. In its place came a reluctant, stunned respect that moved through the gallery without anyone needing to announce it. Reporters began typing rapidly, no longer interested only in the corporate dispute, but desperate to identify the woman presiding over it. Whispers traveled from row to row. Attorneys leaned toward one another, trying to remember where they might have heard her name. Someone finally entered the right words into a search engine. The result sent a visible shock through the room. The woman on the bench was Judge Adrian Whitaker, a federal jurist whose reputation in legal circles was nearly legendary. She was known for landmark decisions, fierce intellectual discipline, and an extraordinary record of helping overturn wrongful convictions during her earlier career as a public defender. Several attorneys visibly paled as they realized not only who she was, but how badly the behavior in the hallway might damage their professional reputations. By the time the court paused, nearly everyone in the room knew her name. Those who did not were urgently trying to learn it. Judge Adrian Whitaker's path to the federal bench had been carved through obstacles most people in that courthouse had never been forced to imagine. She had grown up in a struggling neighborhood on the outskirts of a major city and had been raised primarily by her grandmother after losing her mother while she was still a child. Money was scarce in the most literal sense. There were weeks when meals were skipped, school books were bought secondhand, and every household decision carried consequences far beyond comfort. Even so, Adrian excelled academically. She earned a scholarship to a respected university that many people in her neighborhood doubted she would ever reach. Once there, she encountered a new form of resistance. Professors questioned whether her admission had been deserved. Classmates whispered that she did not belong. Administrators repeatedly demanded that she prove credentials other students were permitted to carry without scrutiny. She applied to law school, despite warnings from mentors who believed the profession remained largely closed to people who looked like her, especially within the elite circles she hoped to enter. Several schools rejected her before one finally offered partial financial support. She covered the remaining cost by working nights at a diner, arriving at lectures already exhausted but refusing to let fatigue become an excuse. She graduated at the top of her class. The achievement surprised almost everyone except the people who had witnessed how relentlessly she worked. After graduation, lucrative corporate firms offered her positions that could have ended her financial struggles immediately. She turned them down and became a public defender instead, choosing a path that paid less because she believed people abandoned by the system deserved an advocate who would not abandon them too. In the years that followed, she built a reputation for exposing police misconduct, challenging unreliable evidence, and reopening convictions that institutions preferred to leave untouched. Her work earned admiration from those who valued justice and deep resentment from those who valued finality more than truth. Her eventual appointment to the federal bench was historic, yet she rarely spoke about it. She remained fiercely private and deliberately understated in appearance. Simplicity was not a disguise forced upon her by circumstance. It was a choice. Those who knew her well understood why. For years, she had quietly observed how people treated her when they saw no robe, no title, no visible power. She wanted to know whether courtesy survived when status was absent, whether respect belonged to the person or only to the position. That morning, in an unfamiliar courthouse, dressed in a worn suit and practical shoes, she had received an answer more brutal than even she had expected. Former colleagues from her public defender years often described the same defining quality in her. She never raised her voice in court, even when opposing attorneys resorted to insults, intimidation, or theatrical contempt. Instead, she prepared so thoroughly that the facts themselves seemed to speak through her. She accepted clients other lawyers refused to represent, cases buried beneath biased investigations, outdated forensic methods, coerced statements, and decades of institutional indifference. She spent countless nights reviewing transcripts after everyone else had gone home, searching for contradictions that had been ignored because the person convicted lacked money, influence, or credibility in the eyes of the court. Several of those cases ended in exonerations for men who had spent enormous portions of their lives imprisoned for crimes they had not committed. Their convictions had rested on fragile eyewitness accounts and investigative shortcuts that no one had challenged until Adrian arrived. Every exoneration demanded a personal cost. There were sleepless stretches spent searching for evidence prosecutors claimed no longer existed. There were threats from people angered by the reopening of old cases and a growing list of enemies within institutions that preferred their previous decisions to remain unquestioned. Adrienne never described those outcomes as victories over particular prosecutors, officers, or judges. She called them proof that justice required constant correction, not blind faith. Her elevation to the federal judiciary had been difficult, despite the praise that followed later. During confirmation hearings, lawmakers questioned her temperament and suggested that a career defending the poor and wrongly accused might prevent her from being impartial. She answered without defensiveness. Impartiality, she explained, did not require pretending inequality was imaginary. It required applying the law consistently, regardless of the identity, wealth, or reputation of the person standing before the court. Her confirmation passed narrowly. She entered the federal judiciary carrying both the weight of expectation and the private skepticism of colleagues who remained unconvinced she belonged. She proved them wrong, one ruling at a time, not through spectacle but through the patient and exacting discipline that had defined her entire life. Back in the courtroom, the session continued beyond its expected pause. The gallery seemed unable to look away, even as the docket moved into smaller and less dramatic matters. The attorney, representing the opposing corporation, soon discovered that he was equally unable to rely on performance. Unlike Hale, he adjusted quickly, recognizing that bluster would accomplish nothing before a judge who valued precision above charm. Judge Whitaker questioned him about jurisdiction and obscure appellate decisions buried deep in the legal record. Her references were so specific that several lawyers exchanged uneasy glances, wondering how anyone could recall such details without consulting notes. She consulted none. Each question seemed to come directly from memory, guiding the dispute away from rehearsed theatrics and toward its actual legal substance. When she issued a preliminary ruling on a procedural motion, the gallery had stopped whispering altogether. They watched in the attentive silence, reserved for moments people know they will later be asked to describe. Court employees who had worked in the building for many years would later say they had never seen a newly arrived judge command a courtroom with such immediate authority. Most jurists required a long period to develop that kind of presence. Judge Whitaker seemed to bring it with her naturally, not because she demanded attention, but because the clarity of her thinking made attention unavoidable. A veteran bailiff quietly observed that the assault in the hallway had not visibly shaken her. If anything, she seemed more deliberate, as though she had taken the injustice done to her and directed its energy into the work before her, rather than allowing it to steal her concentration. The contrast became its own statement. The people who had laughed at her now took careful notes. Attorneys began recalculating how thoroughly they would need to prepare before appearing in her courtroom again. By the close of the session, everyone understood that the incident in the hallway was not merely a story about a violent officer and a misidentified judge. It was the beginning of something far larger. Outside the courtroom, a video of the encounter had already begun circulating. A bystander near the elevators had recorded the entire confrontation on a phone, capturing the document Judge Whitaker offered, Mercer's dismissal of it, the contemptuous laughter, and the sudden strike across her face. The footage escaped the courthouse and reached national newsrooms with astonishing speed. The image of a federal judge being slapped by a security officer inside the very institution she had been appointed to serve was impossible to ignore. The story spread because it touched something deeper than one isolated act. It carried the raw, familiar shape of an assumption becoming authority and authority becoming violence. National broadcasters replayed the footage repeatedly, slowing it frame by frame and examining every movement. Legal analysts appeared to discuss security protocol, professional accountability, and the broader meaning of what the recording exposed about the ways people decide who belongs in spaces associated with power. People who had never entered that courthouse recognized something uncomfortably familiar in the scene. Parents spoke about it at dinner tables and tried to explain to their children how a stranger's unexamined belief could become dangerous when backed by institutional authority. Retired judges wrote columns reflecting on the modernization of courthouses while acknowledging that certain habits of suspicion continued to survive beneath polished procedures. Civil rights organizations issued statements, careful not to exploit Judge Whitaker's own restraint, but pointing to patterns they had documented in public institutions across the country. Attorneys who had never met her defended her publicly, recalling her reputation and expressing disbelief that a jurist with such a record could be treated with such casual contempt. Officer Mercer was placed on administrative leave before the courthouse had settled back into its ordinary rhythm. The security department moved with unusual urgency under the pressure of public attention, and an internal investigation began almost immediately. Few people believed the evidence would support him. Preston Hale faced consequences of a different kind. The clip of his mocking remarks circulated alongside the assault. Clients who had once admired his courtroom charisma began distancing themselves, unwilling to be associated with a lawyer, recorded belittling a federal judge moments before she was attacked. The state bar announced a review of his conduct, citing professional concerns that extended beyond the courtroom but had become impossible to ignore once the video spread. Judge Whitaker refused to participate in the frenzy. She declined interviews, ignored the line of cameras outside the courthouse, and continued arriving for work with the same quiet punctuality she had always maintained. When a reporter finally managed to ask whether she intended to take personal legal action against Mercer, her response was brief and measured. She expected the proper process to proceed properly. Nothing more, nothing less. The restraint of that answer deepened the respect surrounding her. The public story began shifting away from outrage alone and toward a portrait of discipline, integrity, and deliberate self-command. The disciplinary hearing was held later in a closed conference room inside the same courthouse. Mercer sat across from a panel of senior officials. His posture was rigid, and the swagger he had displayed in the hallway had vanished. Asked to explain his behavior, he insisted he had merely been enforcing security rules. He claimed that the woman had refused reasonable instructions and behaved aggressively when he attempted to stop her from entering a restricted area. He described the strike as a reaction to perceived defiance rather than an act of unprovoked violence. The panel listened without interruption, maintaining expressions of careful neutrality. Then the courthouse security recordings were presented. Multiple cameras covered the hallway from different angles. Together, they showed every moment of the encounter with devastating clarity. Judge Whitaker had not raised her voice. She had not shoved him, threatened him, or made any sudden movement. She had produced official identification calmly and taken only one measured step toward the chambers before Mercer struck her without warning. The footage was replayed more than once, including at a slower speed that removed any possibility of confusion. By the end of the final viewing, Mercer's remaining defenses had collapsed. One panel member asked whether he wished to revise his earlier account. He stared at the table for a long time before admitting quietly that he had acted from frustration rather than from any legitimate security concern. That admission ended whatever possibility remained of defending his conduct. Everyone in the room understood that his career at the courthouse was over. In the period that followed, reporters, advocacy organizations, and judicial officials repeatedly asked Judge Whitaker whether she intended to sue the department. Her answer remained consistent. Compensation had never been her goal. She wanted the institution to function as it was supposed to function, with ordinary accountability, applied equally, without exaggeration or special treatment based on title. She had no interest in humiliating Mercer publicly or pursuing vengeance. Instead, she submitted several focused requests through formal channels. She called for mandatory training on implicit bias for every member of courthouse security, beginning during onboarding rather than after a crisis. The training would address the kind of immediate judgment that had transformed her lawful presence into a perceived threat. She requested a clear and transparent system for verifying credentials, one that did not depend on an individual officer's personal opinion about who appeared to belong in a restricted area. She also asked for an independent review process whenever force was used inside courthouse walls, ensuring that future incidents would not be examined only by departments with an interest in protecting their own reputation. Finally, she insisted that the principle behind those reforms be stated plainly. Every person entering the courthouse, regardless of appearance, deserved basic dignity unless evidence, not assumption, proved otherwise. Once those requests became public, the conversation changed. The story was no longer framed solely as an assault on a judge. It became a lesson in restraint, moral clarity, and the difference between personal revenge and structural accountability. Legal commentators observed that Judge Whitaker could have pursued harsher consequences, both professionally and financially. Instead, she used the moment to strengthen the institution for people who might never possess her title or access to national attention. Those who had worked with her for years said they expected nothing else. Her response reflected the same values she had carried throughout her career. Inside the courthouse, witnesses began speaking more honestly about their own silence. Several admitted privately that they regretted not stepping forward when Mercer struck her. Their hesitation had revealed something uncomfortable, not only about fear, but about how quickly a room full of educated professionals could surrender responsibility when authority acted decisively. As the reforms took hold, they arrived without dramatic ceremonies. They appeared instead as quiet, procedural changes that altered the courthouse one ordinary interaction at a time. Every security officer received new training focused on identifying and counteracting unconscious bias during moments of authority. The credential verification process was rewritten to remove much of the subjective judgment that had allowed Mercer to dismiss official documents based solely on who presented them. An independent oversight committee was established to examine any future use of force involving visitors, attorneys, employees, or officials inside the courthouse. Accountability would no longer depend entirely on an internal department judging its own conduct. Outside legal circles, the changes attracted little attention. Inside the building, however, their effect was unmistakable. Security conversations became more measured. Credentials were examined rather than dismissed. Questions were asked before conclusions were announced. Other courthouses in the region quietly adopted similar policies after following the case from a distance. They did not wait for another assault or public scandal to force action. Several judicial committees invited Judge Whitaker to speak about what she had experienced. She declined most of those requests and instead provided written recommendations that could be implemented without transforming her into a permanent symbol or public spokesperson. Whenever asked, she emphasized that the value of the incident did not lie in the uniqueness of her story. It lay in the pattern the story exposed, a pattern repeated in reception areas, corridors, offices, and security checkpoints across the country, usually without a camera present to preserve the truth. Mercer was formally dismissed from his position once the disciplinary process concluded. The department cited his violation of use of force standards and conduct incompatible with the responsibilities of courthouse security. He did not publicly appeal the decision, and attempts by reporters to obtain a comment went unanswered. Marjorie Bell, the senior clerk who had rushed into the hallway carrying the robe, later admitted that she replayed the scene in her mind more often than she expected. She wondered what might have happened had she arrived later, after handcuffs had been applied or another act of force had followed. The experience taught her never to assume there would always be time to repair a wrong once it had begun moving forward. Several junior clerks who had witnessed the assault requested transfers to other floors. They found it difficult to remain in the corridor where they had stood silently while a woman was struck in front of them. Judge Whitaker never condemned them for freezing. She understood how fear, uncertainty, and the weight of official authority could immobilize even well-intentioned people. Rather than shame them, she continued modeling the steadiness she hoped they might one day find within themselves. She returned to the bench with the same quiet focus that had defined her before the incident. She did not allow the violence to become the central story of her career. Her courtroom remained known for rigorous preparation, exacting questions, and rulings grounded in a depth of legal knowledge built through years of difficult and often thankless work. Attorneys who once underestimated her because of appearance learned quickly never to repeat the mistake. Her reputation moved through the legal community with a speed similar to the video, though for entirely different reasons. Lawyers spoke not only of the hallway confrontation, but of her command of precedent, her refusal to tolerate careless reasoning, and her unwavering fairness toward every party before her. Preston Hale eventually appeared before her again on an unrelated case. His posture was subdued, and the theatrical confidence he once wore so proudly had disappeared. Judge Whitaker treated him with the same professional neutrality she offered every attorney. She did not punish him beyond what the law and professional process required, nor did she pretend their earlier encounter had never happened. She simply judged the matter before her on its merits. Long after the incident had faded from daily headlines, a reporter who had followed the case requested a final interview. The question he asked had lingered in public conversation from the beginning. Did she regret not announcing her title the moment Mercer first confronted her? Could the entire ordeal have been avoided had she simply identified herself as a federal judge before the encounter escalated? Judge Whittaker considered the question carefully. She explained that if she had revealed her position immediately, any respect shown afterward would have belonged to the robe, the title, and the authority attached to her office. It would not have answered the question that mattered most. She had wanted to know whether basic human dignity would be extended to a person before power was revealed. The answer she received in that hallway had been painful, but not surprising. It hurt precisely because it confirmed something she already understood too well. What mattered in the aftermath, she said, was not punishing everyone who had failed the test. It was making the system less likely to fail another person in the same way. She spoke briefly of her grandmother and the lessons that had shaped her childhood. Meet cruelty with composure rather than imitation. Confront injustice with clarity rather than vengeance. And never mistake loudness for strength. True authority, she said, had never come from a robe or title. It came from the steadiness with which a person carried herself when no one expected her to possess power at all. The interview ended soon afterward. Cameras were packed away while the courthouse continued around her in its ordinary rhythm. Judge Whittaker gathered her files and walked toward the courtroom for the next docket at the same unhurried pace she had carried on the day she first entered the building. Clerks greeted her respectfully. Attorneys stepped aside without being asked. The corridor that had once held her public humiliation now seemed transformed by her presence. Marjorie remained at the clerk's desk near Chambers. As the judge passed, the two women exchanged a small nod, one carrying more meaning than either needed to speak aloud. Even Hale, crossing the corridor on his way to another courtroom, paused to acknowledge her. The arrogance he once displayed had been replaced by something closer to genuine respect. Judge Whittaker entered the courtroom, and everyone rose. They did not rise because they feared her. They did not rise merely because tradition required respect for the robe. They rose because she had earned their regard through countless decisions made when easier and more vindictive choices had been available. The gavel came down again, opening another ordinary session in an extraordinary career, a session that would never appear in headlines and never needed to. Outside, the city continued its usual rhythm, largely unaware that a quiet revolution in expectation and accountability had taken root within the courthouse walls. It was a change likely to outlast everyone who had witnessed its beginning. Beyond the building, in homes, offices, newsrooms, and conversations shaped by her story, people continued repeating the principle she had expressed so simply. Justice does not begin when someone puts on a robe. It begins much earlier, in the way we choose to treat the people we assume have no power at all. The cameras eventually left. The story moved away from front pages and settled into something quieter and more permanent. But that idea remained. It was carried by everyone who had stood in the hallway and learned, within a few unbearable moments, how much they still had left to understand about dignity, authority, and themselves.